Hello, civil procedure people. Let's talk now about the case of Ashcroft versus Iqbal. This is a U.S. Supreme Court case from 2009, and it is fundamental to understanding federal civil procedure. So, Mr. Iqbal was a Pakistani Muslim in the United States. He was arrested during investigation of 9/11. He was detained, and his complaint alleges that when he was detained, he was treated extra harshly, extra severely because of the fact that he had a certain national origin, a certain race, and a certain religion. And so he, as the plaintiff, names both John Ashcroft and Robert Mueller of the George W. Bush administration at the time as the defendants. So his complaint, it goes into the federal district court, of course. The Court of Appeals ends up saying that, before it goes to the Supreme Court, that Twombly, the case of Bell Atlantic Corporation versus Twombly, does not apply to Iqbal. And if you need a refresher on that video, you can look at my video on Bell Atlantic Corp versus Twombly. But basically, they say that Twombly's heightened pleading standard of you need to include more facts, that you don't just get to recite legal conclusions in your complaint and throw around a bunch of these labels, that only applies to antitrust cases. And they say that on top of that, Iqbal's complaint is better than the plaintiff and Twombly's complaint was, that it has enough facts to get to the point that Twombly's complaint could not. So they say, no, we are not going to dismiss this under Rule 12b-6. So Ashcroft is the petitioner, and at the Supreme Court, Justice Kennedy writes a majority opinion. This is a 5-4 decision. It's pretty much split along partisan lines, like conservative versus liberal. So we have Kennedy writing that Iqbal has not brought his claim from the realm of plausible to conceivable, and he needs to do that if he wants his complaint to go forward to trial. So he grants the motion to dismiss. He says, again, that conclusory claims of a conclusory nature that just throw around legal labels are unworthy of a presumption of truth. He says that Twombly is to be applied to more than just antitrust cases, and that the purpose of the policy that Ashcroft and Mueller implemented, it has not been shown that it was to discriminate. So Iqbal hasn't provided enough in his complaint. So Iqbal loses pretty badly. The complaint is dismissed. There's a dissent from Justice David Souter, who, funny enough, wrote the case of Twombly. And he says that the case is distinct from Twombly. Twombly was only supposed to apply to antitrust cases in federal court, not to all civil suits in federal court. And he says that Iqbal's complaint is also different from the complaint in Twombly because Iqbal has stated enough facts to get past the pleading stage, and therefore they are entitled to a presumption of truth. So yeah, Souter, of course, is joined by Ginsburg, Stevens, and Breyer. So, this case is noteworthy because it changed the pleading standard drastically, that Conley versus Gibson has really been buried deep underground now. There's a really good argument that it's just overruled, that it can't be considered good law anymore. Some people argue that it still is in some ways. But yeah, it's harder to sue in federal court now. It just is. And people who work as defense counsel, they like the cases of Twombly and Iqbal a whole lot. But yeah, as a policy matter, is it like, it might just be too unfair to plaintiffs. And that's something that if you have a policy question in civil procedure, you can definitely write about, that Twombly and Iqbal, and especially Iqbal, basically just took a sledgehammer to stare decisis on Rule 12b-6 motions to dismiss and said, no, the standard isn't that you have to have no facts that would show that you could make a claim. The standard is that the plaintiff actually needs to throw in enough factual enhancement for it to move from the plausible to the conceivable. It's like the nudge test. Nudge it from plausible to conceivable. So yeah, this decision is pretty controversial, pretty despised. Yeah, and it's not that hard to see why. Obviously, it's popular among certain groups who believe that we should have more efficiency and that federal courts shouldn't be handling as much cases. It makes discovery a lot easier, I guess. But yeah, this case is interesting for sure. And it's been the law of the land for 15 years now, since 2009. And rest in peace, Conley versus Gibson. So yeah, that is how Twombly and Iqbal have altered the pleading standards in federal court in the United States. So if you liked this video, if you found it helpful for you, please leave a like, comment, and subscribe. I really do appreciate it. Please help me grow this channel. We can do this. We can educate people, and we can understand the law even better. So yeah, I will speak to you in the next video.